I don't know if you realize we can't hear you.
Yeah, we're done. Can you hear us now?
Yeah, thank you.
Okay, thank you, Liz. Okay, so Dr. Willa, I do not believe that we have any acknowledgements, but we do have a new member here, so can we maybe take an opportunity to introduce her?
We do actually have acknowledgement.
We do.
We do.
Oh, look at that, and flip it over.
Yeah.
Okay,
And then, yes.
so we're gonna do two.
So, we do have, the Booster Club wanted to tonight acknowledge the Booster Club. The Booster Club was kind enough, the Tolland Booster Club has donated a new athletic scorers table that will be used at all home volleyball and basketball games. The addition of this table will allow for more efficient scoring and increased amount of space. And, occasionally we do get wonderful things. The Boosters provided a scoreboard, and so the Boosters are again providing things that are making our sporting experience much better and more wonderful for everyone. So they worked very closely with Mr. McCluskey to design it and get the correct table for our needs. And they have given us that table. So it's just something to be very thankful for. And we deeply appreciate the hard work and effort it went into, into getting that for the school system.
Do we by chance have a picture of that board?
Well, now we're getting out.
Just out of curiosity.
Let me see, do I have, oh, right, yeah, question. Oh, I think I do have
I was
pictures.
gonna say, the next person I would ask is Jaden.
There, actually. Take a second, because everything takes a second. Yeah. Well, it's sideways, but if you tilt your head, you can get a good picture of it. So that is our, the design of our new scores table. Sorry, I don't think I can rotate that in this particular. It's okay.
That's okay, I put you on the spot.
You did what? Yeah. There it is.
Well, thank you very much to the Booster Club for that. Anyone have any questions or anything?
Very cool.
That looks very nice.
Yeah. Okay, so we can move to our second acknowledgements here. We do have, as you know, we have had the pleasure of having Audrey McGowan be our student rep, and she's done an amazing job. And joining her now is Sarah Poulin, who will be joining us to participate and give us all the student perspective as our student rep.
Welcome.
Thank you.
So,
Welcome back, Audrey. Thank you.
do you have any questions or anything?
No, not really.
No, we got sanitizer, that should not imply anything. Everything in here is really clean. So I don't know why we go kind of hammer overboard on that. We're here to help. Okay. We're gonna be-
Good, welcome. And if everyone for both. Okay, we are not approving, moving anything on the agenda. So we go to the approval of minutes. We do have 2 minutes on here. When Dr. Willa had gone back, noticed that we did not actually vote on the April 17th minutes. So those are on here as well as the June 28th. So I will entertain a motion to approve both minutes at the same time.
I move to approve the April 17th and June 28th meeting minutes.
Second.
Second, any discussion on that? And we don't have Dana online, correct? Just want to make sure. Dana, if you're here, please raise your hand. Okay, she is not at this time. So therefore we can go ahead and say, all those in favor can say aye. Aye. Okay, well.
I was
anyone
mad
would like
June
to-
28th.
Sorry. Please do so now. So you have Griffin that is abstaining, but everyone else. So therefore the minutes are approved as is. At this time, I would like to welcome the public participation. We have people online and in the room, and a lot of people seem to be new faces. So just so that everyone knows, we do have a 2-minute timer that Dr. Willett will put up. You were given 2 minutes. And as long as you state your name and your address, which are very important for Lisa to put on for the minutes, You can talk about anything that you would like. It's not a back and forth dialogue, just so everyone knows. The discussion takes place with board members and the points of information. So at this time, if you want to, if you're in the room, the owl will pick you up when you stand up. It just follows you. And if you are online, if you could please raise your hand, and we will go from there. Anyone online? Going once. Going twice. Okay, I will close out the public participation portion, seeing that there are no one interested. Correspondence.
Okay. So just a note again, there are a couple late breaking emails related to the LGBTQ discussion that arrived today. I haven't had time to put them on the report, but they will be on the next one. So everything between now and yesterday, we received an email questioning whether the Board of Ed is playing a meaningful role and is not voting on an LGBT policy before regulation is issued. We had an email thanking Dr. Willett for organizing the town hall meeting on the said regulation. And we had an email asking when the next FFC meeting is scheduled.
Thank you very much. Okay, so at this time, I will open it up to points of information for any board member. If you have anything you'd like to say at this time, please just raise your hand, let me know. Okay, I got a lot of listeners that are ready to move on. Okay. Student representative reports.
All right. So first of all, thank you for the hoodie. It meant a lot. Seeing Dr. Willett show up on my doorstep was my,
It's creepy.
it was my. But no, thank you guys a lot. It meant a lot. And now on to actual stuff. So the fall sports registration and conditioning camps have started, and Mr. McCluskey has extended the sign-up window to August 4th. So if you're interested in any fall sports, make sure to set your registration in by August 4th.
I am a junior class officer, and us junior class officers are planning a haunted house this fall.
And finally, because it's summer and we don't have anything going on, the DECA officers met to discuss the upcoming year and our plans moving forward with DECA. And that's it. Any questions?
Did you say our plans?
I'm the
Meaning
DECA officer.
You're an officer?
Yeah.
Very
This is interesting. Where is the haunted house going to take place? Spooky, is it at the high school or?
Yes, it will be at the high school.
I don't think we've ever had something like that, have we?
Only on Crandall Road years ago, and then not since then, so
I don't think so.
this is cool.
That is neat. Oh,
Is there an age restriction?
We were thinking it would be just for the high school.
Sorry. Having done such a thing and including elementary children. Best thing I've ever done in my life. That's a good move.
thank you, ladies, very much. And I hope you guys are having a great summer, because I know next month school starts. So. I love the smiles. Perfect. Okay, let's go on to Dr. Willett, if you want to start off.
Sure, coming to the first one of the superintendent's report. So we do have tonight, the great benefit of having Attorney Gleason and Attorney Ritter here to go over and talk about the LGBTQIA guidelines and also the CT transgender civil rights in the state of Connecticut, and give the board a presentation and understanding of where things stand. So I have everything queued up here. Where would you like to go?
And as we said, the owl will follow you.
Okay. So is the presentation gonna be on both screens, Dr. Willett?
It will be on both screens.
And is there a
And I
slide
can either-
advancer?
I can give it to you to sit here and just roll them forward, or you can tell me to move them forward. Whatever you
Whatever you prefer, whatever works best.
say beep. And I'll go.
Okay. So, I don't always stick to a script though, so,
No problem.
so hi, everyone. I know that I've had the pleasure of meeting all of our Board of Education members. This is my colleague, Sarah Gleason. I'm sorry to the audience members if my back is slightly towards you. I'm just trying to also be able to look at the screen. So we will be brief. I understand that you have a very busy agenda, so we will do this efficiently and expeditiously. But we've been asked here just to talk about transgender students in the law and what your obligations are under state and federal law. I'm going to talk to you a little bit about the evolving federal landscape, and then I'm going to focus on what the state law has been and what the state law has been for actually quite some time on this topic. And then Sarah will get into some additional kind of Q&A, some issues that I know have recently emerged here in Tolland. So Dr. Willett, if you don't mind going. Beat, thank you. So let's talk a little bit about the national landscape. So what I want to impress upon all of our Board of Education members, and I know how much time you commit to the school district and how much you care about our students. But as you know, the school district has an unequivocal legal obligation to protect the civil rights of all of our students. And here in Connecticut, that also includes the civil rights of our transgender students. And so if there's one thing that you can take away, the recent correspondence, I understand that there were some proposed guidelines that were issued by Dr. Willett that has been the topic of discussion. I want you to know that that is a document that we prepared in collaboration with Dr. Willett that is specifically taken not only from state guidance in collaboration with our Connecticut Department of Education, as well as the CHRO, which is the state agency that enforces discrimination laws here in Connecticut, but it is also based on explicit federal court cases as well as state court cases, as well as agency decisions both at the state and federal level. So really what that is a regurgitation of what the land of the law is here in Connecticut. So with respect to our transgender students, we do not have discretion with respect to saying whether or not we're going to allow our transgender students to use a bathroom or a locker room that corresponds with their gender identity or not. That is not a discretion that any local Board of Education here in Connecticut has. In fact, that is the law. And if we do not comply with that, you will be opening the Board of Education anywhere in Connecticut to significant exposure and liability. And if you are sued for not adhering to the law, you will lose. And so we will walk through the state and federal landscape that supports what we are telling you here. I also want to be clear here that Sarah and I have no political or philosophical agenda here. Our job as your lawyer is just to tell you what the law is. Of course, I'm happy to answer any questions, but as far as we see it, it's pretty black or white on most of these issues and not a matter of political discourse. So let's talk a little bit about the national landscape. When we are looking at the rights of our transgender students and our transgender employees, it is important that we are aware of Title VII and Title IX. So these are federal statutes. Title VII protects against discrimination in the employment context. Title IX protects against discrimination in the educational context. And we will circle back to both of those federal laws, but I just wanted to give you that basic foundation. If you could go beat to the next slide, please. So we will get to Connecticut state law, where in fact, Connecticut has really been on the forefront of this issue. While Connecticut has been on the forefront of this issue, we started to see some significant discussion about the rights of transgender students through the Obama administration. What we saw in the Obama administration is that in 2016, the U.S. Department of Education, in collaboration with the U.S. Department of Justice, issued a Dear Colleague letter. In that Dear Colleague letter, it made very clear that we, the two agencies that would be charged with investigating discrimination claims brought forward by students, we interpret Title IX to encompass discrimination based on a student's gender identity, including the transgender status. So that is what the federal presidential administration is telling us in 2016, and it further summarized what they believe is a school's obligation with respect to Title IX. Now, why is this important? Well, if you are not compliant with Title IX and you are not compliant with the guidance that has been issued by the agencies that are charged with enforcing those laws, you could lose significant federal funding. So in addition to losing significant federal funding through Title IX or through Title VII, we also, of course, have some legal exposure, which Sarah and I will get into more specifically. So if we could go to the next slide, please, Dr. Willen. So this is just a quote that we wanted to share with you that specifically comes out of the Obama era guidance that says the departments, and here they're referring to the Department of Justice and the Department of Education at the federal level, treat a student's gender identity as the student's sex for purposes of Title IX and its implementing regulations. This means that a school must not treat a transgender student differently from the way it treats other students of the same gender identity. Now, they rely on this interpretation to also say that means that if I am born a female, but I have a sincerely held belief that I am a male and I want to use the male locker room, that is my civil right to do so. That is my legal right to do so. Same thing with the locker room. I want to use a locker room. I was born biologically a female, but I identify as a male. I legally have to be allowed to do that. Now, one of the alternatives that they talk about in the correspondence is that you can have a neutral bathroom, but you cannot force a transgender student to use that neutral bathroom. But that neutral bathroom is really there for anyone's level of disability. So if I feel uncomfortable having a transgendered student change with me, I can go use the neutral locker room, or I can go use the neutral bathroom. But as we start to see, and we'll get a little bit more into this, and Sarah will talk about some of the case law, what we have seen and what has emerged, especially more recently, is my religious objection or my discomfort to the civil rights of a transgender student does not outweigh their legal rights. And so I want to be very clear about that I know people are going to, and I understand this is a complicated issue, so I'm not, again, asserting any opinion on anyone's religious or philosophical objections, but I'm here to tell you that the law of the land right now is going to say that does not outweigh a transgender student's right to express their gender identity and expression. If we then could go to the next slide, please. Go to the next slide, please. So then I just want to talk a little bit about 2017, because I think this is where some of the confusion comes in, because in the federal landscape, things have kind of flip-flopped, whereas in Connecticut, the law has been more consistent. But we see our Obama era guidance is rescinded in 2017 by the Trump administration. So the Trump administration says, we don't agree with the Dear Colleague letters or the FAQs or any of the information that was presented by the Obama administration, and we are advising the US Department of Education and the Department of Justice to not take into consideration transgender status when looking at the Title IX regulations, basically saying that sex under Title IX does not encompass transgender status, contrary to what Obama was saying. When they rescind this, though, they are very clear. However, as we are rescinding this, we still very much defer to the state's right to implement educational policy as the state sees fit. So they're giving significant rights to the state, and that's when we'll start to talk a little bit more about Connecticut. So not only do they say, but there should be due regard given to how a state wants to deal with this issue at a local level. But it also says, though, even though we are rescinding the Obama era guidance, it doesn't mean that we don't support our LGBTQ community, and it doesn't mean that they lose their legal protections, and school districts still have an obligation to protect them from discrimination, bullying, and other harassing forms. Let's fast forward to our Biden administration. So the Biden administration in 2021 issued an executive order basically saying, I'm going to trump the Trump guidance. And this executive order, I'm going to be showing the world that the federal government is committed again to including and making sure that when we are implementing Title IX regulations, that we are also protecting against the discrimination of our transgender students. So that is issued as an executive order. And then there are proposed significant changes to the Title IX regulations in June of 2022, which are still in the proposed format. That is specific to athletics. The other proposed regulations that we're talking about, which should be coming down in October, which Sarah will talk more about, is specific to Title IX, the implementation of those regulations and how it impacts. There will definitely be a component of how it impacts our transgender students. And by all accounts, we have been informed that the definition of sex will encompass transgender students. So it will more mirror what we have in Connecticut. That is not finalized yet, but that is what we've gathered so far. So I just wanted to give you a little bit of kind of the federal landscape. So then let's move to this case. If you can move to the next slide, Dr. Willett. So here is the Bostock case. Now, the reason why this is an important case is with a landmark decision in 2020. This was issued by the United States Supreme Court. And this was specific to discrimination under Title VII, which we talked about in the first slide, which deals with the employment context. But the decision issued in this case has also set precedent for how other judges in other jurisdictions have interpreted Title IX. So I think it's important that we talk about it. This case was a trio of cases. So we had one gentleman, I'm just going to pull up my notes here so I get it right. Gerald Bostock, who is the named plaintiff here, he was a child welfare services coordinator, fired after his employer learned he had joined a gay softball league. Then we have Donald Zarda, who was a skydiving instructor, He was fired after his employer learned he was gay. And then we have the third case, a funeral director, Amy Stevens, is fired after her employer learned that she was going to transition from male to female. So the Supreme Court takes all three of these cases, consolidates them, and issues one singular opinion that basically says, because they were fired for being in the process of transitioning from male to female, or because they were fired because they were gay, that is discrimination on the basis of sexual orientation or gender identity as prohibited by Title VII. So now they're encompassing the word sex to include sexual orientation or gender identity. The reason why this is important is that if we go to the next case, we have a series of cases. So Dr. Willett, if you could go to slide 8.
Yeah.
We have a series of cases that after the fact use this landmark decision to support holdings of Title IX with respect to our transgender students, which really is impactful with respect to here in Tolland and all of our other local school districts. So here you have the 11th Circuit determined that the school board violated Title IX by its bathroom policy, which prevented a transgender student who identified as male from using the boys' bathroom at the high school. What the 11th Circuit looked at is they said, here we have school officials who by their own admission and by their own testimony consider this student a boy in every respect. This child was identifying and presenting as a male, and it was a sincerely held belief that he was a male. However, their bathroom policy said that he could only use the multi-stall girls' bathroom or a single-stall gender-neutral bathroom, and they held that this was in violation of Title IX. So that goes back to what we know is set forth in those guidelines that were issued and also that are consistent with what we have from our state officials. So then if we could go to slide 9, I want to talk a little bit about Connecticut law. So that is just kind of a brief overview, and it's complicated and it is constantly evolving. But I wanted everyone to understand kind of what's going on the federal stage. And then I just want to talk briefly about what has been going on in Connecticut since at least 2011. So Connecticut is probably one of the first states, if not the very first state, to add gender identity and expression to the state's anti-discrimination laws. So that was as early as 2011. Public Act number 1155 protects against discrimination in employment, education, housing, public accommodations, and in any other areas in which sexual discrimination is prohibited. It also authorized persons to file complaints with the CHRO alleging discrimination. So if a transgender student felt that they were being discriminated against in any local school district in Connecticut, they would file a complaint with the CHRO. And they are authorized to do so by this public act. If we go to the next slide, codified within this change back in 2011 here is how the Connecticut State Legislature defines gender identity or expression. So this is taken specifically from Connecticut General Statutes 46A-51, where Public Act 1155 was codified. You all have a copy of this. This is a very comprehensive definition, but just briefly, a person's gender-related identity, appearance, or behavior, whether or not that gender-related identity, appearance, or behavior is different from that traditionally associated with a person's physiology or assigned sex at birth. If we could go to the next slide, please. In Connecticut, we also have Connecticut General Statutes 10-15C, where they have reaffirmed Public Act 1155, and they have added discrimination in public schools are specifically prohibited, including gender identity or expression, meaning you have to provide an equal opportunity to all of our students to participate in our educational programming free from discrimination based on any protected class, including gender identity or expression. If we could go to the next slide. So the correspondence that Dr. Willett, I know, shared with his staff and had shared with the Board of Ed is largely taken from the Connecticut State Department of Education's guidance on these issues. Now, when I say guidance, I don't mean to suggest that it's discretionary or doesn't have the effect of binding law, because it does. And if you look at the very first footnote in this document, and we do have copies for you so you can take it, it is very clear that this is an interpretation and that this is an affirmation of Connecticut's laws, also of Title IX, and also in collaboration, the viewpoints of our public agencies, which are charged with looking into discrimination complaints, the CHRO, and then also complaints with respect to students, the Department of Education. So this guidance, just so you know, the impetus behind this guidance, so this is from 2017. There is a working group now at the state level that will be reissuing a guidance. We have no reason to believe that it would be much different from this, though we do think it will address some very complicated questions that may come up that the 2017 guidance doesn't. But I want to be clear that the impetus behind this was after Trump rescinded the Obama era guidance on protecting transgender students, Governor Malloy directed our state agencies to come out with a document like this, reaffirming that in Connecticut, it has always been the law since 2011 that we view the transgender status of our students as a protected class, and that he asked those two agencies to put together this guidance. Sarah's going to talk to you about what is contained in this guidance, but I need to impress upon you that some of the features taken from this is this guidance is not discretionary, and it is critical that we share this guidance with our community members, that we share this guidance with our staff, that we offer professional development on these issues, because they need to know what the law is and they need to adhere to the law. And so I can't impress that enough, that this is not something that you have discretion over with respect to these issues. So Sarah, if you want to just talk briefly about how a child would establish gender identity in the school context.
Yeah, for sure. If you move the slide down one, thank you. So I'm going to kind of talk through what is in that guidance. It's going to seem very familiar if you've read the guidelines, because it's taken from that, right? So you're going to hear a lot of the same things and see a lot of the same things. But establishing gender identity, right? That's a big piece of what is in that Connecticut guidance. And it says that students are not required to produce specific documents that reflect their gender identity, right? You don't have to produce paper that says you don't have to produce a specific record or a specific document in order to be treated consistent with their gender identity or expression. And regardless, schools are required to address a student in a manner that's consistent with their gender identity or expression, even if their education record has a different sex in that file, right? You still have to address them as in a manner consistent with that gender identity or expression. And they've made very clear in that Connecticut guidance that refusal to address students in a manner consistent with their gender identity will have serious civil rights implications on the part of the district, for all the reasons that Jess just kind of went over, right? From all of that, different federal and state guidance and different laws. How do you go down one more? So how do you show gender identity, right? That's another question that comes up. That's another thing that's discussed in the guidance. There's no bright line test, and they're very clear about that. There's no one way to do it, but they do give you kind of 4 things to be thinking about, although it's very clear that this is not an exhaustive list. Medical history, right? Care or treatment of the gender-related identity. Consistent and uniform assertion of that identity. And then, any other evidence that the identity is sincerely held. You heard Jessica use that phrase a lot, right? It's sincerely held. So any other evidence that it's sincerely held, it's part of a person's core identity, and that they're not asserting that identity for an improper purpose, right? That's a key piece of this. So again, that's not all of the ways you can do it, but those are the 4 ways that are laid out in the guidance of showing gender identity. So a couple of kind of the questions that are answered in the guidance, because just, to be clear, there's the Connecticut guidance, and they also issued a companion FAQ document that basically reiterates the guidance in a different way, right? In kind of an FAQ format. But some of those questions that come up are, is consistent expression of a particular gender identity required to establish that gender identity? And that Connecticut document is clear that you do not have to have consistent and uniform assertion of a gender identity throughout, right? That is one way for an individual to indicate their gender identity, but it's not a requirement that an individual consistently and uniformly asserts themselves as a male or a female. Part of that's taking into account gender fluidity, which is actually defined in the guidance and something that's talked about extensively. But they're very clear that you do not have to have consistent and uniform assertion, although that is one way to show gender identity or expression. And then, and just to be clear, right, what's on your screen is taken directly from the guidance, right? This is how the State Department of Ed is explaining these issues. And so the question of, do transgender students need to provide documentation? I mentioned earlier that they don't, right? Students are not required to produce specific documents or any documents at all that reflect their gender identity in order to have the right to be treated consistent with their gender identity. Schools are expected to treat students consistent with their gender identity, regardless of kind of what the records show or what their documents say or don't say, right? There is no requirement that they produce specific documents for that. So with that kind of background, right, what about names, pronouns, gender markers, some of those things, right? The guidance, again, is clear. Schools have to address the student in a manner that's consistent with their preferred name, which could also be their chosen name, their pronouns, right? Whether that be he, him, she, her, whatever their expressed pronouns are, and their gender marker. So whatever a student is asserting as their preferred name, their pronouns, their gender markers, the school has an obligation to use those when addressing students in the schools. Keep going down. So how does the school right respond to requests to use a different name? When that comes up, schools should consistently refer to students by the requested name or the pronoun, right? Regardless of whatever sex is on their records in their file, regardless of their birth sex. In doing that, schools have to accurately reflect the chosen name on all records going forward, right? If a student has said that they haven't chosen or preferred names, that's what has to be reflected. You don't have to have a legal name change to utilize that chosen name. So again, that goes back to the idea, right, that you don't have to have a specific record. You don't have to have a legal name change to be using a different preferred or chosen name. So you can see that example there. A transgender girl enters high school and asks the principal to inform the teachers that even though the name is John, right, on the records, that student prefers to go by Jane. And that's not only completely acceptable, but you're required now under the law to refer to them as Jane.
Yeah, we often get the question whether or not family actually has to go through probate court to get a legal name change. And it used to be that it was done that way, but the guidance has since changed. And so there's absolutely no legal requirement that someone go through kind of the legal hoopla to change their name.
Okay. Go down one more, please. So conflicts between parents and students are a big issue, right? And that's an issue that there's no clear guidance from the State Department of Ed, from any sort of federal agency on how to resolve the dispute. But there are some appropriate best practices, right? Regardless, the guidance is clear that the school has to continue to address the student in a manner consistent with their gender identity, right? Regardless of any sort of conflict. So when they're in that school building, they get to be addressed using their names and pronouns of their choice. Where there's appropriate, right, the school can provide supports to assist the family and ensure the well-being of the student. This is going to be very different for every student, right? This is going to be where we're going to have to look at each student, family dynamics, what's going on in that student's personal life, and how can the school best support that student. And sometimes that might be a conversation with legal counsel, a conversation with other people in the school building, but working together to figure out what is best for that particular student. This question, as I'm sure you can imagine, right, has garnered legislative attention across the country. There's more than 3, but we have 3 cases here all across the country of school districts kind of grappling with this issue. And the answer is there really is no answer. They're kind of all over the place in the terms of how the courts are coming down, but then also all of them are on appeal at this point, right? So we still are waiting for those kind of higher level courts to come down and give us some more guidance, right? Because that's really where we're getting a lot, as you heard from Jess earlier, right? Some of those, the Bostock case, right? That is from the the US Supreme Court. So we may be getting there soon with some of these issues. So I'll have you go down one more. I'll just talk about these 3 cases briefly, because again, they're all on appeal at this point, but this one actually came from Massachusetts. And this one was where a court upheld a school district's policy allowing district personnel to withhold information related to students' gender identity from the students' parents. So that was, you know, a case that the court actually said it was apprehensive of the policy and the actions of the school. And, you know, the parents and the students would be better served with a more thoughtful policy, but nevertheless upheld that policy at the lower court level, right? That's on appeal. We'll see what happens and what the district courts kind of decide with that. But again, that's just kind of showing how a lot of courts are coming down on some of these issues, really on with the rights of transgender students and protecting those rights.
In addition to that, the state working group that is reissuing the 2017 guidance, we hope that they will elaborate more on some of these complex issues that schools are navigating. I think what we would say is, on balance, we of course want the parents involved. We of course want the parents to be made aware if they aren't already, though in most situations that we have dealt with, the parents recognized what their child may be going through, and they want to work in collaboration with the school. I mean, that has been 9 times out of 10, that has been our experience. And it is a very collaborative process, and we work closely with the families through support and counseling services to appropriately address the child's transition in a way that is healthy and safe for that child. In the rare circumstance, you might have a situation where the child says to you, if you reveal this to my parents, I will be placed in imminent harm. And unfortunately, as a mandated reporter, that would mean that our school council would have to call the Department of Children and Families to report something like that. Because if a child fears that they're going to be physically harmed if they were to reveal this, we have no choice but to make that call. So you can see how these are very complex, because then the parents will eventually know that that call was made, and they will probably then become aware of this information. So these are very complex issues, case by case basis, no one size fits all. But of course, as educators, the child is always going to be at the forefront of our minds. And of course, we want to work with families to the extent that we can under the law. And I do hope that that guidance that we receive in October will help school districts navigate some of these complexities better than it does now.
I agree, and I actually was speaking to somebody this morning who said that there is a working group both to update the 2017 guidance and also a working group specifically to deal with these issues of when there's disagreement between students and parents, and kind of how to navigate some of those more complex issues. So it's coming, it's just a matter of when, but that will hopefully provide a lot of helpful support to the school staff and to the school districts generally. Let me go down again. Again, just another lawsuit in Wisconsin. Again, where a parent was bringing a lawsuit alleging that the school district violated parental rights by adopting policies regarding transgender students and regarding, parental consent. And in this case, right, the court denied the school district's motion to dismiss the lawsuit, meaning the lawsuit's still alive. So the court's gonna figure out, where do we land on this? So it's a little bit different, right, than the Massachusetts that said that this type of policy was fine. And so it just goes to show how this is across the country, a huge issue right now and something that the courts are all grappling with in a different way. And we'll see what happens with this. This is also on appeal. I think we're expecting a decision in, I think, 6-ish months is what they said, so we'll see. But again, it's not in Connecticut, it's not gonna affect us directly, but it will kind of start to paint the landscape of what we can expect to see with these specific issues. And the final one in Maryland District Court, where a similar policy, right, that really protected transgender students, protected their rights, and protected, their ability to make decisions with differing levels of parental involvement. And, the judge there found that the guidelines advanced the state's goal of protecting student safety and privacy and sided with the Board of Education on that. Again, we'll see, this guidance is similar to the Connecticut guidance that has been issued. And so it's just another court kind of reaffirming that this is, what is the law right now.
So Dr. Willett, I think we can probably jump ahead because the student records, I know we talked about extensively. So if you could just keep going. So if you could just go back up to the restroom and the locker room. So, I mean, certainly add something if you think, Sarah, but I think, what is clear from our state law and our federal laws and the guidance, like we have said before, you have to allow a student to use the restroom facility, the locker room facility, with the gender that they identify with and with the gender that they are expressing. And so, I don't know if there's any other questions about that. I think what's important here is that, it is clear, and I don't know if you're currently doing this now, that you can provide access to a non-stigmatizing alternative, such as a single-sex, unisex bathroom. But as we mentioned before, we can't force anyone to use that facility, even if it means that someone has a religious objection or has discomfort as a result. I don't know if there's anything else you just want to add quickly about the facilities.
No,
the
it's I think, and well, just to go off for the locker rooms too, it's the same exact analysis that they have for restrooms, where you can always offer that gender neutral alternative.
Okay,
Just so you know, this is just the board meeting and we're not doing questions from the public.
okay.
She says I have a question.
Okay.
And so can we jump ahead then? So I just want to briefly. So I just wondering, just to the right here. So Board of Education members, and again, this isn't the Socratic methods, you don't have to answer it, but what you think from this scenario we have here. So we have the district and the family communicates extensively about issues such as the student's name change, registration as a female, access to girls' restroom and locker rooms, and eligibility for girls' athletics. The district honored the student's request in all aspects, except her request to be provided access to the girls' locker rooms at the high school. Do we think this is discrimination based on what we've just discussed?
Yes.
Okay, so let's go to the student versus township. So this is a case from dating back as far as 2015, before we even started to see the federal landscape shift and start to really address these issues. So this is a direct case from the Office of Civil Rights, who reviewed and did an extensive investigation. And they certainly saw that it was discrimination, and they opined that the district had impermissibly relied on privacy concerns of the other students, and that by making privacy curtains available and still not permitting the transgender female to change in the girls' locker room, that was a violation of her civil rights. You know, one thing that I also think is important is when we talk about liability and legal exposure, there's also significant costs attached to this. And so I believe that through a resolution agreement, they reached a settlement in excess of $200,000. So we also, right, you are fiduciaries to your local school district. We want to be conservative, make sure that we are adhering to this legal advice so that we don't find ourselves having to use our valuable and scarce resources to pay settlements of this nature, right? So if we want to just jump ahead, I don't think we need to do the other scenario, but I do think it's important that Sarah just provides you with a brief update. If we could skip ahead, Dr. Willett. I know that there has been also a case that has generated significant buzz and attention because it is in Connecticut with respect to athletics and transgender students. And so Sarah is just going to briefly touch upon the status of that case.
Yes, this is the Sewell case. This is straight out of Connecticut. And in brief, it was cisgender female high school students who ran track, brought a suit against the CIAC's, which is the Connecticut Association of Athletics, right there. Their policy that allowed transgender females to compete in female sports. So that's the policy. These female plaintiffs brought this case, and it went up the circuit, went up to the Second Circuit at one point. And they were seeking an injunction that said that the policy violated Title IX, right? So we talked about Title IX earlier. They wanted the court to say that a policy allowing transgender females violated Title IX, and then they requested monetary and other relief. The end of the day, the court found that the claim failed because they did not allege what they called a cognizable deprivation. And any claim of their loss of future employment was too speculative. And they did not have standing at that point, right? So they kind of dismissed it on those grounds. Nevertheless, the Second Circuit Court of Appeals reheard the case just recently in June of 2023, and a decision is pending. So we're still kind of waiting, like with a lot of those cases I talked about earlier. But as it stands now, right, that CIC policy has been deemed to be, you know, legally compliant. And that kind of plays into what we have coming down the pipeline from the federal level, which we'll go to the next slide. So these are the new proposed Title IX regulations for sex-related eligibility criteria in athletic teams. So basically, right, we think of Title IX, sex discrimination, part of that is athletics, right? So the federal government is coming out with specific regulations related to that. And what they've said is, and these are the proposed, right? We're not exactly sure when they're coming down with final ones. They could potentially change at some point, but this is what they came out with at this point. And these proposed regulations say that school policies cannot categorically ban transgender students from participating on athletic teams consistent with their gender identity. So they're gonna, you know, that these regulations now will not allow school districts, right, to categorically ban transgender students from participating in the sport. However, they do say that schools can use sex-related criteria in their athletic eligibility policies when such criteria substantially relates to important educational objectives and can be implemented in a manner that minimizes harm. What does that exactly mean? You know, we're not sure at this point. We're waiting for more guidance from the Department of Education, but you know, this just goes again to show that all of this is being thought about, and it's being thought about, you know, very meticulously by these agencies, state and federal, and they're trying to help schools kind of navigate these issues. And so when those come out, we'll of course kind of let you know what those are. And then finally on the last slide, there's also new regulations coming out related to Title IX and sex discrimination. And I just point out only one thing is that those regulations now will specifically include discrimination on the basis of sex to include sexual orientation and gender identity. So Jess, I remember she already said that that's how Title IX is being interpreted based on those court cases. And so now these new regulations that are coming out are simply going to codify that. They're going to put it into the law. And so we expect those to come out in October of this year.
So every document that we referenced, including the presentation, we have copies of, which I can leave with Dr. Willett. We did put together packages for you so that you can have that information. And so certainly if other questions emerge, you know, certainly reach out to Ashley or Dr. Willett. We'd be happy to address anything. I don't know, Dr. Willett or our board members, if there's anything else that you would like us to highlight.
No,
I think this was very thorough, to be honest. I think it has a lot of answers to the questions that we've either received from the community or as board members had. At this time, does anyone have any other questions? Go ahead.
I had a question about one of those court cases that's currently making its way through the court. I think it's the first one, Foot v. Ludlow. I had two questions. Number one was, is that in a federal district court or like a state court?
It's the state court.
Okay, but it could still eventually work its way up. And the second question was, it's like, do you know any, thing about like why the court decided the way it did? Like what grounds it was? Just kind of curious what the argument is.
Yeah, so,
Yeah.
you know, it was a little, the court, as you see here, right, it says it was apprehensive of the policy. The court didn't go into too much detail, honestly, and I think that that's part of the reason why, it was appealed so quickly. But they, you know, they said that the state has, and the school district has an interest in protecting students' rights, protecting transgender students' rights. And, so, you know, they kind of gave deference almost to those policies that the school district created to protect those rights. And, you know, as you see here, the court said although it was apprehensive perhaps of that policy and thought maybe there could be a more thoughtful way to serve the same interest. Nevertheless, it was protecting the interests of those students. And so
Okay, thank you.
That's it.
It's very thorough.
Well, I think we want you to understand, look, it's complex.
Yeah.
And it is still an emerging area of the law and it's navigating a lot of complexities, but I do think sometimes people are confusing the federal proposed regulations with how that impacts us here at the state. Because what's happening in Connecticut is different from what the evolving landscape has been at the federal level. So I think that has lended to some of the confusion. But I'm happy to leave, why don't we leave these packages?
Yeah, Tony does have,
yeah, did you have that question?
Yeah, just as far as, so the guidance that's Dr. Willett put out, that if I understand correctly, was pretty much coming from the recommendations that the guidance said that you were generating, stays fairly ambiguous as far as when this communication with the parent should not occur. Was that intentional? Or
Yeah, I mean, I think it really, so I don't disagree with you, Tony, and the reason why we don't have a bright line rule is because it's going to be very specific to the facts of that case. I mean, as lawyers, we wish there was more of a black and white answer to that question, because we often have to navigate that question with our superintendents, with our administration. You are not the only district grappling with these issues. In fact, we've given this presentation in a lot of places. My hope is that through the proposed regulations coming down from the federal government and then through the think tank at the state level, which is supposed to also issue some FAQs, we will get additional guidance on this, because right now it's really just, again, trying to balance everything that we know here while also understanding that parents have significant rights too. So it's really just a balancing act right now, but I wish I could give you a more definitive answer because we would like one.
thank you.
you know, I would like to say that it would be nice to have this presentation available for the public to see. I don't know if we have that as an option to post it somewhere, just in case people want to.
We'll have the video meeting.
What was that?
I still have the video.
Meeting.
Yeah, yeah, that's true.
So I
I
have,
have no problem with you posting the,
yeah, I posted it to the dashboard, I'll post it.
Yeah, of course.
I just had a quick question. Jess, you said that
I'm just gonna leave these here.
as mandated reporters, the school would have to contact DCF if the student felt that they were going to be in physical harm. Is it just physical harm, or would that also?
Well, emotional harm, you're right. I should have also said emotional harm, but I guess I was trying to impress upon the fact if the child said, I can't go home, whether it be emotional, psychological, or physical, if you share this with my parents. you're right, that would trigger a DCF call. So you're right, it's not just limited to physical, it would be psychological and emotional as well.
And just for the public, I'll be posting the presentation to the LGBTQIA link off the superintendent's page, just so you know where to find it.
Is there guidance for our staff to know the difference, I guess? So, for example, my one son said to my other son, "Mom's gonna kill you if she finds out you ate her, whatever." So, you know, how does the staff make that determination if a child says something more along those lines, like, "My dad's gonna kill me if he finds out"? You know what I'm trying to say?
Yeah,
So-
there's significant
Okay.
training.
Okay.
And you have to have training on DCF or refresher course every 3 years, and you have to have it within like the first month of your employment.
Okay.
I would say that if you look at the legal standard for when you call DCF, you have to reasonably believe that the child could be in imminent danger, whether it be emotional, physical, or psychological. So I think if someone says in jest, "Oh, my father will kill me, ha ha ha," in jest, that's not going to trigger the call. But I will tell you that my advice has always been to mandated reporters, if you can't tell, you call. Even if that means that DCF says, "I'm not taking the case," I also want to protect our staff members from liability for failure to report. Because we've seen over the years that a lot of school administrators or educators, if they fail to report, can also be criminally liable, even if they weren't the perpetrator of the abuse. And so if you can't tell, I would call in an abundance of
I
caution.
feel like it would be such a tough thing for an educator, because having a child then have DCF come out could be, I would think, very traumatic as well.
I couldn't agree
So
with you
there's
more.
no,
So we deal with
Like
this
it's
all
such
the
a tough-
time, where an educator will say, "But this is going to ruin my relationship." Let's say I've worked really hard with this family, I have finally connected with this family. If I make this call, it's going to destroy all that work it took to have credibility with this family. But the problem is, by not calling, who knows what could potentially happen to that child, right? But also, the law really does hold them accountable from a civil and criminal standpoint, and so it could absolutely destroy your career if you don't make that call. I've also seen that with staff members not wanting to report on their colleagues. That has been an issue as well in other places, but again, I have to impress upon them that you will be impacting not only the district and the child, but also your own livelihood if you don't make that call.
Just to build upon Christine's question, so as Dr. Willard already stated, when these situations come up, we have a Title IX coordinator at every school, and the Title IX coordinator will be involved. Would that then take some of the responsibility off, saying, you know, English teacher, Mr. Smith? Would he necessarily be the one calling DCF in a
Yeah.
situation like that, or would he refer to the Title IX coordinator and have a
The
discussion?
obligation lies with you. So if I saw the abuse, if the report was abuse to me, now that doesn't mean I can't go to my Title IX coordinator and we call together. But I am not extinguished from my responsibility by passing it off to someone else, because then that person could decide, well, I wasn't there, I didn't hear it, I don't think it's worthy of the call. I can still be liable because the responsibility lies with me. I can't push off my responsibility to someone else. And if I go to my Title IX coordinator and the Title IX coordinator says, "Don't report it," and I feel that I need to report it, I'm gonna report it. And I've advised educators to do that.
Just building off that, that's within 12 hours too, right?
Yeah.
That's within a certain time frame.
Yes.
Yeah.
Right.
Now,
You know.
there is a distinction where if you don't believe it to be an imminent threat, you could report it online within 24 hours. And they have said that they're not gonna hold it against you if they deemed it imminent and you didn't. But the only time that I would advise in the 24 hours is if it's something where you have very little facts and someone told you that they heard something from, 15 years ago that isn't sexually related. I mean, there's very few situations where I would tell you to use the online platform, but it does come up from time to time where that's an acceptable form as well. But you always want to call as soon as you have that information. Now, lots of times DCF doesn't take the case. So, Christine, to go back to your point, it might be that I call, I still don't know whether I should be calling, but DCF doesn't take it, and then the parents or the educator never know that I called. and I can remain anonymous. So that's also helpful too.
Any other questions?
Okay, well, thank you guys very much. Always a pleasure to see you. I'll leave that information here with you. And if you have any further questions and if you want to post the presentation, please feel free to do so. Thank you.
Yeah,
You already did it?
I did it.
Of course you did. Very efficient.
Thank you, Sue.
Okay, thank you guys. Take care.
Thank you. Okay, let's move on to the transportation contract. And just once again, for everyone at home, we put it onto, what was the link?
It's, if you go on the district site, superintendent, and then along the left side of the superintendent's page, there are options. One of them is LGBTQI. Click on that. It has a lot of documentation, and it has this presentation at the top.
Thank you.
All right, so, I'm just trying to get this to kind of a little bit of where I wanted it, but it's not. So I'm just gonna talk off this. If you look inside the Board of Education dashboard, there is a link to a folder that includes these three documents, the Tolland Public School Transportation Contract, and then Exhibit A, Exhibit B. So the Tolland Public School Transportation Contract, as you know, we went out to bid. You know what those, you know what the results of the bid were. And so we've been in negotiations with the transportation company to achieve the contract. At this point, we are very close to finishing it. It does have financial adjustments for if targets are not met. It has a language for us to have the software for parents so that you have parent tracking for for the buses as they're going through their routes. It has basically everything that we were looking for with respect to the services. Additionally, the bus fleet has been increased to 34, and that will help a lot with timeliness because we were short by about 4 or 5 buses before. Now we have enough so that we can reintegrate them into the routes, and that the routes will be inevitably shorter because we have more of a bus fleet. So that will help in that way too. So parents will have a much better view of where the kids are. The fleet is larger. There are still provisions for, what we can do from a resource and financial perspective if, things aren't hitting targets. There are monthly reports required that they have to do. And as you know, when we talked about this and we were in the budget season, we worked with the company and were able to get, these are the rates. We were able to get a provision for, creating an increase each year that would benefit us from a financial budget perspective, rather than getting a 13% increase in 1 year. It's a 9.5, an 8.75, and a 5. And if we continue and want to extend it for the following years after that, it's 5%, 5%. So what I was going to do, and it's just a basic overview. Tonight, I was providing this documentation for you. Obviously, there's a lot here to read and so on. To process it, and then on the dashboard, there is a link to submit your questions. You submit them, you have till August 4th to do that. I'll get all the answers and I'll get the attorney's answers and I'll provide those answers to you. And I'll also see if she's available for the next meeting. I'm not sure if she would be, but I think any questions you have, I can get the answers for. This is a very good contract, even comparatively with other ones in the state. Some of the other districts that have been going into negotiations have ended up with much, much higher percentage increases. So this is a very favorable contract for us. It has everything in it that we wanted. And as you go through it, I think you'll see that. And with respect to other ones out there, it's probably one of the best ones I've seen. So we're very fortunate in that way to have the relationship that we have. So it should solve a lot of the challenges and struggles we've had. And I think it'll be something that the board will appreciate, especially as time goes on. see a lot of difference.
I have a question.
For the targets, I know that we went at great lengths talking about who, what, and where, decide what those guidelines are of how late they are, or if they don't show up, or who is still doing that now? for this
So
contract?
within this contract, I mean, throughout the state, you have an hour. So roughly you have an hour. But within this contract, what we have is language that says that it's defined by, a certain number of minutes around the stop. And that I have some discretion to determine with them what reasonably that is. So so again, it would discourage the idea of, normally it's around 10 minutes from 8:10, and then one day it's, 8:60, 8:50. Yeah, well, that's still within an hour, but it's 40 minutes off of what the parent would expect it to be. I would have some leeway to hold them accountable for that. Having said that, the software now will show a parent exactly where it is, kind of an Uber-esque form. So there might be something happening where they divert traffic from exit 67 through exit 68. We've seen that happen. When that happens, and anything happens on this thoroughfare here, right through the center of Tolland, it greatly delays anything that has to use that road to, cross between areas of town. So, that kind of thing can sometimes happen where you're expecting the bus at 8:10, but it really doesn't get there until 8:40. And sometimes it might have to do something like this, but the parent would be able to see where the bus is and, and see that it's locked up for some reason and not moving much on, wherever this is. 195. I know on that end it's 195. I don't know what it is. But anyway, you can see that it's locked up on 195 and you might see the bus rerouting. So it should really empower parents from a point of view of information. The bus fleet being increased will lower the amount of time the routes take. And the accountability measures are within this document. So it's a really good one, especially considering, again, keep in mind, we did a process this year. And that process ended in a way that you're very familiar with. So, there are a number of outcomes that could have occurred from this that are quite different than the one we have. We have a good contract here with them, and we had one of the lower percentages in this, comparatively around us.
That goes into my next question for the software. How do we know for the safety protocol that, is it like a per bus? Is it going to be a per district? Like, you sign in and then you have like certain.
Yeah, I mean, these things change fairly frequently in terms of updating and making them better. So it's either an app or some page, but my impression is that it's an app.
So it's like your kid will be one of those Apple.
You'll be,
I just, my
it'll
question
look
is,
like the
I just don't wanna
GPS that you probably see.
I mean, it sounds silly, but I just don't wanna, I wanna ensure that it's the parents who know where their children, it's not just like an accessibility to the world and say, okay, here's the, town school bus, 15 here comes over here.
Yeah.
So I just was wondering what kind of security, like what.
Well,
encompasses
security
that.
or.
Well, the security to know, like, the parents, like, yeah, a control set, that it's the parents,
Yeah,
that the kids.
You're probably,
Gets access and how.
well,
There you go.
you're probably going to be able to drop down to select bus 11 and then the large bus 11's going or something. That would be something.
Yeah.
But once again, who,
How do we get access?
Yeah, Galashian should have access to bus 5, but Tony Bolt shouldn't have, or, or.
Right, I
somebody
don't
outside.
know for sure
the
the
district.
answer to that. But I assume like we've done in the past, we've linked things to certain ID numbers, and usually parents have those and other people don't.
Okay.
And we've done that in the past, so it's probably following a similar paradigm.
That's the type of question that could be investigated before.
Yeah, ask that question and then I would run big on this basis.
well, that is my question, because
Yeah.
I would like to know, like.
Now,
my
in the
child-
RFP, we ask that they provide a software for parents to track. The software, as it's released from different companies, may do things a certain way. Whether we can ask for modifications in pre-existing software that does this, that wasn't necessarily an RFP. Yeah.
I would just say, I'm sure it's secure from their point of view because they have to ensure their whole
operation.
Reliability would be high.
Right, it would be safe for them to have that software accessible to just
They are liability sensitive.
information.
I just think about the little ones and, you know,
Yeah.
just.
But they themselves don't want to disseminate that information. So,
Is that going to be up and running for the start of the school year, the software, the ability to access it?
As far as I know, yes, but we have to make sure, we have to get this process done first.
We have to say yes to the contract in order to get it that far.
I will read the contract, but just curious, have we addressed the athletic buses in the new contract?
Because we'll have more to be able to flex, we should be able to manage that better too. We have more in the fleet overall, so we can dispatch or combine, you know, certain things.
So for the penalties, if standards aren't met, can you just kind of give us a 45-second pitch about
Yeah,
that?
it's a
Yeah.
monetary penalty that we can, apply against the coming bill.
Perfect.
And that would mean that anytime we see something, we keep track of it, and then we could, then pay a certain amount less.
Okay, and was that in the previous contract? I'm trying to,
There was language in the previous contract for that too, but we did get money.
okay,
You know, there were various things where the Purdue provided funds back to the district. And during COVID, they did actually a very good job of applying quite a bit of funding back to the district. So we've had a pretty good relationship with that. And they have areas where, we don't follow through with certain things. For instance, I can't just arbitrarily reduce the number of buses. Because they have logistics, they have to hire people, they have to pay people, they have to bring training on insurance. So you'll notice in there that if I say I want to go from 34 to 30, then they get to charge more for the buses that remain. Because they have logistical things they have to go.
okay.
Just to remind everybody that this was the only bid that we got for buses. And, we will have to, on that August 9th, make sure that we vote on that to make sure that we do have buses for the start of school. So if everyone could take the opportunity to look through and ask any questions by the 4th, that would be great. And you have a question.
Yeah, and maybe this is a form, a Google form question, but just today in curriculum, we talked about outplacements and, students being driven from Tolland to, Crack or whatever it may be. Is that included as well on those buses?
I mean, because you don't know how many you're gonna get, when, how, and why, that tends to be something that sometimes you have to add.
Any other last questions? I think we're looking good. So, just make sure you get those questions in back and forth.
What I'll try to do is, as you get them in, I'll try to get the answers. But by the 4th gives me a good shot at making sure I got all
Just so you know, the security one, I'm not gonna put it in there, but that is a question. Make sure they're there.
I'll try, I'll put it in.
We'll type it in for you. Okay, let's move on to field trip update.
So, as you know, what I've been doing these days is just, instead of, kind of doing it, all at once, I do it as it goes. So we have another field trip that came up. It's a Costa Rica field trip. Looking at, doing that April 6th through 13th, 2024. Grade levels are 10 to 12, about 30 students would participate. Board doesn't have to take any action on these. These are just things that come across my desk and I check and I, either approve or deny. I approve this trip to go. It has various really great educational benefits. There are certain financial aspects that allow kids to go that may be struggling. So it's a good trip, and this is one of the world language trips. They've wanted to be doing a series of world language trips. So this is one of them, and they've done others in the past and want to do more in the future. It's just giving you the update about when it comes across my desk. I try to get it in front of you so you can see it as they go. It's fun.
Yeah.
Yeah.
Is that during break?
Apparently there's a lot of sloths. There's a sloth sanctuary down here. Go around with sloths, zoology, everything.
I can't,
Yeah.
I can't imagine Miss Canty is the only one attending that, the only staff member attending that trip, correct?
Well, usually it's a 1-to-10 ratio, but she's the one who submitted it.
It's under her bill.
Rough average.
Just out of curiosity factor, I don't know if you have the information, but how much does a trip like that cost for
It
students?
will usually cost a couple thousand.
Hmm.
Yeah, in fact, yeah, it's usually, and depends, if you get everybody, you could knock some of it down, and the more people that go, it can be a little bit less, but it's in the thousands.
Per student?
Per student, like 1,800 to 2,000.
I feel like I'm dating myself, but I feel like my, my trip to France when I went in high school was about that. So it seems like a pretty good deal. Okay, any other questions? Okay, moving on. Let's move on to committee and liaison reports. I know there was a lot of cancellation things going around, so forgive me, but you're gonna have to just let me know because it's been a heck of a week for me. Go ahead.
Got a couple. So earlier this month, the mental health and substance use task force met. To continue to discuss a recommendation to hire, either a wellness coordinator, I think is the title we're settling on. Which will be funded partially through, grant money that Human Services received. That position would, work to implement many of the areas where we felt that there were shortcomings. Also, just a general note up on the task force, we're looking at winding down operations for the task force. I think we even mentioned August potentially being the last meeting. Although I'm not sure if that's confirmed, but it's definitely winding down its operations. It's unclear right now whether it will be replaced with a permanent standing commission or if responsibilities are going to be folded into local prevention council. But that's kind of where the discussion is for that.
Was August when they were gonna go to the town council for it? We were discussing on
Yes.
when. Yeah.
Yeah, and I think we scheduled a regular meeting in August as well. Yeah. But yes, you're right, they'll go to town council for that recommendation. Also, curriculum met, earlier today. We had a good discussion. We reviewed mastery-based learning. We just want to revisit some of those big topics from time to time, so we discussed that. We also, were able to look at some numbers in terms of the number of outplacements, that the district has had.
Well, again, to differentiate special ed house placement versus.
Oh, yes.
Different things,
yeah.
but yes, the tuition.
Yeah. So just to be clear, referring to students who might go to a magnet school or some other high school outside of Tolland High School, not special education. But we were able to get some data that looked at this over the past, it shows 5 or 6 years. Plus this out of district tuition spend that the district has to spend for those students. And got an idea of how much we're spending per year up on that. Those materials are now on the dashboard.
Every time we have a meeting, anything in the committee thing is always on the dashboard at the bottom. There's folders for each, so it's in.
So,
Good question. How much is it?
so right now, I think it was highest, in 2017 that we looked at for the data anyways. I don't know what.
Yeah, fiscal year 18 was the highest and
Yeah.
we're, but 18 to now, it's dropped about down.
Yeah,
20 or 30,000.
yeah, it was something like 230,000 at its highest, so we were spending, now it's below 200,000.
207 now, and it's about 47 now to 36.
Yeah, in terms of number of students. So definitely a good resource to have, especially when budget season comes around and we have conversations about cost avoidance. This, I think, should serve as useful reference material.
Thank
That's it.
Oh, FFC did not meet, right?
Policy met today. We covered policy 5081, which is bullying prevention and intervention. Discussed that a little bit. Most of it is updates and changes to align itself with current regulations. That one has been approved out of committee and is in the queue for leadership to take a look at. We discussed 5700, as it's right now being titled, which would be the LGBTQIA+ civil rights policy. We took a look at the initial draft, had some questions, some really good conversation. Wanted to wait and listen to what tonight brought and do a little more reflection. We're anticipating the next meeting will be the last meeting where we make some minor changes, and then that it's predicted to bump out of committee at that point.
Can I ask you a question?
Absolutely.
When Jessica was talking about the state coming down with new guidelines in October, does it make sense to, not that I know we don't want to hold off anymore, but does it make sense to see what, if the state changes anything or,
I think it does.
okay, sorry.
But no, and that's a great question, but along the same notes as the guidance, I think it's important that we get the best that we have as of right now out there. If the state comes down and has any sort of changes, policy committee can pull it back in and do reflections, but I think we want to get this out. But we do think, and everybody on the committee, I think was fairly committed, that one more meeting should be all it takes. And then we'll be ready to pop that up to the board as a whole. We also then covered policy 4142, which is retention of electronic records and information. The policy was about 13 years old, and so it had to be updated with things such as Twitter and Snapchat and various other software that I have to ask my kids about. But it essentially, our new policy will reflect what Chicken and Goodman have put out. We modeled it after that. So that one also popped out of committee and will be awaiting review.
This time, I don't think there's anything else or anything, so.
I did want to, we did not have a most recent communication meeting, but I did want to thank Dr. Willett for finalizing the letter to the legislature. And thanks to the board members who signed it. And then we are currently in teacher negotiation.
This question, I know you can't go into specifics, but is there like an ETA about when that might be ready for the board to vote on?
Teacher negotiation?
Yeah, we just started.
Yeah.
Now, just so you know, it is a statutory timeline, so we have to be, if we don't get it resolved, we go into mediation automatically, in September, and then arbitration automatically again.
Is it really September and October?
Okay, well, it's not that far.
But the para one, we should be getting that probably pretty soon, once they ratify that.
Yeah, they have to ratify before we then vote.
Okay, thank you.
Okay. No report, we don't have board action, so at this time, we will open up public participation and the rules still are the same. If you could please list your name and address for the record. This public participation needs to just be with items that we discussed today during our meeting. So if you are online, you can raise your hand. If you're in the room, you can raise your hand, and then I will have you come up. Dr. Willett will put the 2-minute timer up, and we will go from there. So we'll come up. Just give him a minute to get himself situated.
Okay, I'm ready.
Okay, he's ready. So name and address, please.
Lisa Davis, 63 Tolland Green. I have a question. I don't know if you'll be able to answer this, but if not, maybe you could bring it back to Shipman. It was about the policy and the regulation regarding transgender students' use of bathrooms and locker rooms that align with their gender identity, their preferred gender identity. And this question comes from the knowledge that, being kids going through a transition, some transgender students might not choose to go and use the bathroom of their chosen gender right away or ever. It's a decision that is, holds a lot of anxiety and concern because of the other peer reactions and bullying and just comfort level. So I wanted to ask whether or not there's any guidelines in
you know, that about, okay, so a transgender student identifies as male, but chooses to still continue to use the female bathroom. Whether it's, you know, that or the opposite. Whether or not, there's any guidelines, to that nature. I know that a lot of gyms in Connecticut, they say that the, participants can use the bathroom there of their comfort level. So that's kind of, what the question entails. Will that be something that the school, adopts or considers as the comfort level of the student? Whether or not they want to use the bathroom of their sex assigned at birth or their gender identity.
Anyone else? I would like to go online. If somebody would like to go online, I can go back to the room if there's anyone else. If you want to raise your hand, please do so now. Anyone in the room? No? Okay. I will close out the second public participation, seeing no hands. Okay, points of information. So at this time, if any board member would like to respond or have anything else to say, please do so now. Or if you, Dr. Willett, want to say anything too, I want to exclude you.
No.
Okay. Okay, so at this time, we'll be entering into the executive session once we do a vote for the purpose of the superintendent's evaluation. So I will entertain a motion to go into the executive session for the purpose of the superintendent's evaluation, inviting Dr. Willett.
So moved.
Seconded.
Okay, all those in favor can say aye.
Aye.
And did you say aye?
I did.
Okay. Well, I heard you.
Okay.
Okay. Nope, nope. Okay, so at this time, we will be entering into, executive session for the purpose of the evaluation at 8:30, sitting at 9:17. I would like to entertain a motion for adjournment.
I moved to adjourn at 9:17.
Second.
20 seconds, all in, any discussion? No, okay, all in favor, say aye. Everybody, thoughts all in favor? We will end at 9:18.